Okay, good morning, good morning, good morning. How is everybody today? Great. Boy, we're getting more and more people. I'm going to start dividing you all up in two sections pretty soon. For those of you who don't know me, most of you know who I am and who Mike is. My name is Craig Hirsch. I'm a Florida Bar Board certified attorney, Shepard, Brett, Stewart, Hirsch, Kinsey, and Hill. I'm here today with one of my law partners, Michael Hill, who you all know, and then one of our associates, Blake Hampton, and we also have some of our legal assistants here today. So, if you do me a favor before we get going, if you happen to have a cell phone on you, please silence it, if you would. Yesterday we gave a presentation on Sanibel and for new clients, and it was like a cacophony of a symphony of rings and whistles. Oh my God. Yeah, which makes it tough on me because I have such a one-track mind that when I go to talk and I get interrupted like that, I completely forget where I am. Maybe that's a sign of age now. So it's nice here to be in Southwest Florida, isn't it? Even though it's raining today. My oldest daughter, Gabby, is a sophomore at Brandeis University up in the Boston area in Waltham, where about every 3 days they're accumulating another foot of snow. And I said, well, you know, she hasn't complained, but I'm ready to say you're the one that chose Brandeis, you know. But she's enjoying it up there. Now today in our maintenance program, but what we're going to talk about today is protecting your assets, protecting your trust in the assets that you've accumulated. A lot of our clients are under the impression that when you put assets into your revocable living trust, that they are protected or somehow exempt from the claims of creditors. But they're not. They are not. Let me tell you a quick, brief little incident that happened in our office just a few years ago, that highlights this. We had a client who was involved in a terrible automobile accident with a motorcycle. She was driving an automobile, and she actually, I don't know if she injured or killed someone on a motorcycle. And her automobile coverage was the standard, like, you know, $300,000, $100,000. You're all familiar with that? That was not enough to cover the damages, the loss of life or the loss of injury or limb. It was one of my law partner's files, so I don't remember the exact details of it. But what we were worried about was that the plaintiff's lawyer, and you know, the problem around here, we don't have enough plaintiff's lawyers, isn't it? I never see him on television. You can't turn on the Today Show without watching this guy every 50 seconds, right? So those guys, you know, when there's not, you know, the insurance company, what they're going to do in an accident like that, they're just going to settle for policy limits, right? Does that make sense? You know, the guy has $1 million injury or something like that, and, you know, the policy, you know, we pay up maximum of $300,000. Insurance company writes a check for $300,000, sends it to the claimant, and they say, we're out of it. We're out of it. So now client's on her own. She has to pay for defense counsel, and that alone can be tens of thousands, if not hundreds of thousands of dollars. And then ultimately, there might be a judgment against her. And in that case, what happens? Can they go after her revocable trust assets? You betcha. See, your revocable trust during your lifetime is yours, isn't it? You can do with it as you please, right? You can, you know, it's under your Social Security number, it's a tax identification number. You don't file a separate tax return for it, right? So it's really your assets. You know, the trust is there to, of course, help in the event of your incapacity. It's there for many good things, to avoid the probate process. There's a lot of good things that your trust does, but it is not protected from the claims of your creditors. So what Mike and I are going to talk to you about, we're going to talk about several things. And the first thing, let me just kind of back up. What else are we protected from? Well, you know, a lot of you are retired, so you don't think that a lot of these apply to you. Like, you know, if I have a malpractice suit, can clients get to Craig Hirsch's assets in his trust? Yes, if it's beyond my policy limits. Those of you who are business owners, right? You have liability, don't you? You know, you might have liabilities, slip and fall, customer in your store. You might have liability to vendors, you might have liability to customers, you might have employees who sue you, so business owners have liability. Those of you who live in homes, do you know about what an attractive nuisance is? Do you know what that means? It doesn't mean parading around naked in front of your lanai. And certainly for me, that would not be an attractive nuisance. But what an attractive nuisance is like a swimming pool or a trampoline. Let me kind of give you a little bit of the law on that. If I have a swimming pool, and even if it's enclosed by a cage, like a pool cage, and my 5-year-old neighbor comes into my property uninvited, opens up the door of the pool cage and drowns in my pool, can I be held liable for that? Yes. Yes. Because my pool is deemed to be an attractive nuisance. Same with like a trampoline. In fact, my kids, true story, when my kids were younger, we actually had a trampoline in our backyard. And then when all the, trying to renew for windstorm and homeowners insurance, do you realize that one of the insurance companies that would only insure me if I agreed to remove the trampoline from my yard, and they actually sent an agent out to inspect and take pictures to make sure that I actually did. That's how serious they are about that. So if you have an attractive nuisance, that could be something that could create liability for you. Those of you who own rental properties, we're going to talk a little bit about what you might do to protect yourself. If you own your rental property in your revocable living trust, all right, and let's say that somebody, remember a few years ago in North Carolina, there was those college kids out on the Outer Banks, and the property burned to the ground and 6 of them died. Do you remember that in the news a few years ago? Well, if that fellow who owned that rental property had it in his revocable living trust, that might subject all of the other trust assets to that liability beyond the insurance limits. So if you have a rental property, this is something to consider. And then finally, even if none of that applies to you, how many of you drive? Okay? So if you own an automobile, you have something dangerous that could lead to liability. So what we're going to talk about, and I'm going to turn it over to Mike in just a minute, Florida law actually provides us some real, Florida's a very, very good creditor protection state, believe it or not. It really is. Mike's going to go through these. These assets that I have up on the board now, and everybody has a copy of these slides in your hands, do you not? So you can follow along even if you can't see the board. Homestead, life insurance annuities, wages, IRAs, 529 plans. There's particular exemptions in the Florida statutes that protect these types of assets, and there's a lot of sub-rules to them. Now today we're just going to go over the surface of all of this. Today is a surface conversation. It's not a real in-depth conversation. But at this point I'm going to turn it over to Mike, who's going to go into more depth into the exemptions that Florida law offers.
Great. Thanks, Craig. Hey, good morning, everybody. And again, like Craig just said, Florida has it's a very, very liberal state when it comes to granting us these exemptions. Homestead is kind of the biggest one, and that's the one that we're going to start with. So let's first off, how many people are familiar with the homestead exemption, heard the phrase homestead exemption? Who can explain what you think that means? Well, where does that apply for most of you? Where have you heard that from? What's that? Property taxes, that's exactly right. There are really 3 different types of homestead exemptions in Florida. The first one that most everybody is familiar with is the property taxes. We go down to the Darth Vader building downtown and we file our homestead exemption, right? And we get $50,000 off of our property tax bill, off of the assessed value of our property tax bill. That's just one element of homestead. The second element of homestead that many of you are also familiar with, because I know we've talked about it, are the descent and devise rules. We can't just simply disinherit our homestead, so we're exempt from doing certain things with our house in our estate plan. So a lot of you will have a provision in your trust that says, hey, my house goes to my surviving spouse, period. That's the second element of homestead. But the third element is very, very important for creditor protection, and that's this exemption from forced sale to pay creditors. This is in Florida statutes. It's also in our Florida Constitution. And what it says is the equity in our homestead is exempt from our creditors. Our credit card debts, for example, or a slip and fall or an accident or a general liability, if I have a major, major claim, they cannot force me to sell my homestead in order to pay off that claim. Okay, powerful, powerful exemption because it's really unlimited in value. I can have my McMansion out on Captiva or Sanibel or whatever, and $2 million worth of credit card debt, and they can't force me to sell it to pay off that debt, to pay off those bills. Now, a couple exceptions. There's always exceptions to the rule, and the major exception are secured creditors, the mortgage, the bank. If I borrow the money to buy my big house because I'm trying to protect my assets, the mortgage company can foreclose, so that's an exception creditor. A few years ago, we found out that the IRS is also an exception creditor. The Kraft case, which was a U.S. Supreme Court case, said, we don't care about Florida's homestead exemption. The IRS can go straight to it and force us to sell it. But absent those types of creditors, the homestead is very, very, very powerful protection. Now, it's not only just our single-family home, but it also is condos and our mobile homes or our manufactured homes or our villas or our townhouse or whatever it is. As long as you own it. Now, there is one other very, very important exception. It's not so much the value of the homestead. It's not so much how big the house is. It's how big the land is. Okay, so the major exception here is it's limited to 1/2 acre property size inside of a city limits, or up to 160 acres outside of the city limits. Okay, so if I've got a farm out in East Lee County that's not inside of a municipality, that's not in Lehigh proper or whatever other town or even Fort Myers, up to 160 acres is going to be protected. And again, it could be right on the river, nice long stretch, and worth millions and millions of dollars. It's going to be protected as long as it meets that size requirement. Now, what about how many? I don't want to ask how many people live on Sanibel, but I've got a lot of clients who bought property back on Sanibel back in the 60s or in the 70s before it became a city, before it was incorporated. There is a grandfathering rule. So if I bought property outside of a city limit, that's, let's say, worth an acre out on Sanibel, that's an acre out on Sanibel, and then 5 years later, they incorporate, and Sanibel all of a sudden becomes a city. When it happened we were just out there, I saw the sign, 1974, I think. Does that sound about right? So when it became a city, if I had over 1/2 acre before, I'm grandfathered. So there is another exception to this exception, because if you bought the property that's over 1/2 acre before this town became incorporated, it's still protected. Okay, very, very powerful. This is why we see, when the Enron folks, when the Enron things happened, when O.J. Simpson got into trouble, they came down here and bought big houses to protect their assets. Because there's a case, the Havico v. Hill case out of the Supreme Court, that said, hey, this last bullet point, the transfer of non-exempt assets, cash or stocks or bonds, into a new home or to pay down my mortgage on my existing home is also protected, at least under current law. It's protected. So if I have a big judgment up north, I'm going to flee to Florida real quick, and I'm going to buy the big house on the river or on the Gulf or on the ocean and try to protect my assets. So under today's laws, that still has been upheld, hasn't been overturned yet. I'm sure that we're waiting on a test case of really, really bad facts to challenge that again, but so far it's still upheld. So homestead exemption, very, very powerful here in Florida for creditor protection. Next up, another statutory protection, right in Florida statutes, is the life insurance and annuity. The cash surrender value of your life insurance, or the principal balance of your annuity, is protected for you during your lifetime. Okay, this is the cash surrender value, also the death benefits, while you're alive. Death benefits aren't necessarily protected, though, for the beneficiary once you've passed away. This was at our last workshop where we talked about how do we protect inheritances for the kids. Okay, this particular slide, this particular topic is your personal life insurance, the cash surrender value of your life insurance. When you die and you leave it to your kids, if you leave it to them outright, well, it's exposed to their creditors at that point. Okay, now we talked about the last workshop, we hold it in continuing trust, let them be in control of it. We can still provide some creditor protection for them. Annuities are pretty liberally construed as well. It also includes private annuities and personal injury settlements. So if there was an accident and you got the insurance company that's paying you over the years, as very well is the case most of the time, and a lot of times they give you a lump sum, but sometimes they'll pay you over years as an annuity structure. That'll be protected. And even when you pull the money out, unlike the trust that we talked about last time, if I've got my insurance policy, I can actually tap into my cash surrender value, and it's still protected as long as I do something with it. So the concern there would be is if I have $500,000 worth of cash surrender value in my policy, can I actually use it? Can I do anything with it, or does it just have to sit there? Under Florida statute, the proceeds and the use of that, I can pull it out, and as long as I just don't put it in my bank account and have it become an available asset, I can put it into, I can pay down my mortgage, or I could do some other planning with it. So very, very powerful here with the life insurance and the annuity. There's also some thought out there, and I don't know if this has been tested in any case, but there's also some concern about if you were not a Florida resident when you bought the annuity and became a Florida resident, can you use Florida's exemption for annuities and life insurance? Not quite so sure. They might not be exempt. So think about this. If you were not a Florida resident and you bought the annuity 10, 15, 20 years ago and then became a Florida resident, it's not quite so clear cut that those priorly purchased annuities are exempt. So just a little exception there that we want to be careful of. Next up, the wage exemption, another statutory exemption. Basically, your wages are exempt, can be exempt. So wages, earnings, and compensations for your personal services, your personal life. So we're talking about W-2 wages. We're not talking about capital gains or earnings off of dividends or stocks or whatever. You also have to be a head of the household. So you actually have to be supporting somebody. You've got to have a family or have a spouse that we're using these funds for. Now, one exception, again, to the exemption is we might not have the wage exemption depending on what we've signed. So if we've borrowed money to buy a house and the mortgage company tries to foreclose, they can foreclose the house. We saw that a minute ago. But for the deficiency, can they come after our personal wages? We might say, hey, we've got a wage exemption. No, you gotta leave. But and a lot of times those mortgage documents and the promissory notes, you may have inadvertently or unknowingly waived your wage exemption. So we always want to be careful depending on who the creditor is. We might not necessarily have this. And when it's both the husband and wife and both of them are working, only one can be the head of household. So only one person's wages are going to be protected or going to be exempt. Craig and I, early in my practice, we were still in the old office, so this was probably 2004, must have been 2003, 2004. Craig and I actually wrote a Florida Bar Journal article on the wage exemption, because the other exception that's not listed here is business owners. There's a whole line of cases, and it at least was clear back then, I think it still is, that if you are a business owner and you're trying to protect your own wages under the wage exemption, again, that might not necessarily work depending, because as a business owner, I can manipulate my wages and I can determine what my own wages are. So they threw out my entire ability to have a wage exemption, which makes no sense, of course, but that's the way the cases have fallen with the wage exemption. So again, another pretty good one. Next up, again, this one's going to hit home. IRAs, retirement accounts, 401ks, those types of things. Again, very protected under Florida statutes. We actually talked about this at the last workshop as well, because we talked about it in the context of inherited IRAs. And I think we put up the Florida statute on it as well. But the public policy here is Florida doesn't want to have retirees being subject to, having all of their assets subject to their debtors. That we want to make sure that you have some assets so we're not left destitute in our retirement. So Florida statutes clearly protects it for you, your IRA for you. Depending on the way you read the statute, it looks like the beneficiaries, the inherited IRA beneficiaries might have protection, but there was a case, again, out of the Supreme Court that said no, inherited IRAs are not protected. And so protected for you, not protected for them. And another thought, again, some articles that we've read is if your IRAs or your assets are not held in a Florida institution, are we going to be able to use the exemption? Because remember, whenever you open those accounts, you sign that big, long, the legalese custodial agreement that has all the fine print in it. Guess what one of those provisions, one of the provisions are in that type of document? Any guess? What's that? Governing law, bingo, there you go. And usually what is it, where is the governing law typically? Where that state is. So if it's Vanguard, I don't know where Vanguard's now, I guess Delaware, but Pennsylvania. So Vanguard's main base is in Pennsylvania, and if that custodial agreement says everything's going to be governed under Pennsylvania law, can I use the Florida IRA statute on a Pennsylvania? Maybe not. So the thought is, if we want to be absolutely as conservative as possible, we want to make sure that we have this, let's look at a Florida custodian or something that was clearly governed under Florida law, so we can make sure that we get the exemption. But this is another really, really good one. We've used this a lot. Next one, 529 plans. So if we've created a 529 plan for our children or for our grandchildren or great-grandchildren, those again are protected, as long as we're using it for the qualified purposes. If they take the money out and don't spend it on education, yeah, they're going to pay a penalty and they're going to have some tax consequences, but it's also going to be exposed to their creditors or to the creditors of the beneficiary.
Mike, for our statute, I think it has to be a Florida-specific 529.
Oh, does it have to, again, same type of issue. If I set up a Vanguard 529, now a lot of those that I've read are actually set up in California for some reason. I don't know why, but same concept's going to apply. Is it a Florida institution? Is it a Florida 529 plan, Florida prepaid plan? Last one. This is the biggest of them all. Not really. Our cars. Our cars are exempt, but they're exempt up to $1,000 of equity. So congratulations. I guess my car might only be worth $1,000, but most of our cars have equity over that. So this one's kind of a weird one, because with Florida being so generous in all these other exemptions, my guess is similar to the tax code. They probably set $1,000 a long time ago when it was really, when it had maybe more meat to it, and they just never indexed it for inflation, and they just never changed it. So it's still $1,000. Other ones, medical savings account or HSA accounts, those types of things. If we set up the trust for minors, the UTMA, the UGMA accounts for minors, those are protected. Unemployment benefits. Hurricane savings accounts. Craig and I were joking. I never even heard of that one. So I guess there's a little money we can put in that, and the disability income. So those are kind of the major statutory exemptions right in our code that we get when we're Florida residents, and very, very generous, like I said, more so than most states. So now I'm going to turn it back over to Craig, and he's going to talk about what do we do with anything that's not covered by those exemptions.
All right. Usually I give you the tough stuff.
That's right.
Today you got the statutory ones, and I get all the creative stuff here. So Mike went through all of the statutory exemptions. You all clear on that? You can pass the test tomorrow? No problem? All right. So no, as Mike said, Florida is very, very generous with our exemptions. Although, like he said, there are a lot of exceptions to them. So what do we want to worry about when we have other assets? And now we're going back really to your revocable trust, because your trust really isn't covered by any of those things that we talked about, is it? Your trust assets are usually just your personal bank accounts, your stock and brokerage accounts, those sorts of things, right? So we're going to talk about the various things that you might want to consider, and this is the laundry list of them. An umbrella policy we'll talk about in a minute. The way that you own things jointly if you are married. Testamentary trusts, which we talked about. How many of you were at our workshop in November? Were a lot of you here in November? Okay, for those of you who weren't, Mike, are we going to have that on the web soon?
Yeah, it's in process.
Okay. On our website, we're going to be posting the video, just like we're taking the video right now. In the next few weeks, we're going to have the video of our November workshop on our website, and that talks about when you leave assets to your spouse or to your children, how are they protected? So if you're interested in that, and some of this bleeds into that, watch the video. We put it up on the web. Maybe we can get out a mass email to everybody. Yeah, when you get an email from us, take a look at that. And by the way, if you please don't mark it as spam, because then we can't send out mass emails if too many people mark it as spam. You can always opt out of the emails, by the way, and we don't send you a lot anyway. Lifetime irrevocable trust we're going to talk about, as well as some family partnership and LLC type planning. So does that sound good? Okay, let's first talk about umbrella policy. How many of you have an umbrella policy? By show of hands. Many of you. Very, very good. For those of us who have a car, You know, remember I talked about all the various dangerous things that we all could be suffering liability from, car being probably the most common. An umbrella policy is really critical. It's a policy, for those of you who don't know what an umbrella policy is, it's a policy on top of your homeowner's or your renter's policy and your auto policy, and if you have a boat, your boater's policy. And in order to get an umbrella policy, you usually have to have the highest limits in all those other policies first. So you always want to check with your insurer to make sure that the policy limits on the underlying policies, on your car, on your home, on your boat, or whatever, are at their highest limits, or at least the limit that the umbrella policy requires. Then the umbrella policy will usually cover an amount in excess of that, maybe $1 million, up to $1 million, or you can even buy $2 million, $3 million, $5 million. You might be surprised to learn that it's only a few $100s, let's say, to up it on an annual basis, at least with my policy. And I have a 20-year-old, an 18-year-old, and a 15-year-old, you know. So I'm going to have, you know, 3 drivers in addition to my wife and I. But it's only a few $100s to increase from, let's say, a $2 million policy to a $5 million policy. And if you have, you know, $3, $4, $5 million of assets, you might want to increase it that much to make sure that you have that kind of coverage. Now, the other thing about umbrella policies is there's something called uninsured motorist coverage. Are you all familiar with that? Okay. For those of you who aren't, anyone want to hear what uninsured motorist coverage is? Okay, you know, there's a lot of drivers out there, particularly here in Lee County, who don't have adequate insurance, automobile insurance, liability insurance. In fact, there's a lot of drivers that are driving illegally without any liability insurance at all. And if they were to get in an accident with you and you suffer damages and they don't have any insurance, they're for the most part judgment proof. You know why they're judgment proof? They don't own anything. There's nothing to go against. So if you are involved in an unfortunate circumstances where you are in an accident with somebody who has either very low coverage or no coverage at all, uninsured motorist coverage on your policy will cover you up to that limit. It's a claim against your own policy. So first of all, make sure that you have adequate uninsured motorist coverage on your automobile policy, but then you can also purchase uninsured motorist coverage on your on your umbrella, which I think you can't purchase more than $1 million. I think is the limit on that. But you might want to check with your insurer, because I'm not sure if that's what the limit is anymore. But that's a good idea to have. In fact, my law partner, Mike and I's law partner, Hugh Kinsey, his wife was sitting at an intersection several years ago. Fellow ran a light and she was just sitting there. She was not moving. Her car was stationary. And she suffered tremendous injuries from a guy hitting her. And that fellow, of course, had very little coverage, as I recall. So they had to go against our uninsured motorist policy. So it's something to consider if you don't have that on your coverage now. Let me talk about tenancy by the entireties. A lot of people think that they can protect their assets by simply putting things in joint name. If you just hold your question at the end, we'll take some questions at the end. If you, a lot of people could believe that they can just simply put assets in joint name with their spouse and protect it from the claims of creditors. Let me talk to you a little bit about that. There's 3 types of joint ownership: tenants in common, joint with rights of survivorship, and tenancy by the entireties. Tenancy by the entireties can only be owned by a husband and wife. And the only way to get it is to actually title an account or title an asset as tenants by the entireties. A lot of times banks will open up an account, John and Mary Smith, joint with rights of survivorship. That's not tenancy by the entireties. Generally speaking, under Florida law, tenancy by the entireties assets are protected from only one of your creditors. So if, let's say I hit somebody in my car and injured them, and I have an account jointly with my wife Patty as tenancy by the entireties, and she's not liable on that lawsuit, then that asset is generally protected. Now, for those of you who have trust, we really don't want those assets in joint name, do we? Because if something happens to both of you, that's a probate asset. So that's one reason why not to have tenancy by the entireties. Another reason is the protection goes away if you're in the middle of a problem and your spouse happens to pass away or you get divorced. And in order to open up an account as tenancy by entireties, it has to have unity of time and unity of interest. In other words, it has to be on the same account at the same time. You both sign the same forms. If any one of those requirements is not satisfied, even though the account may say tenancy by the entireties, it really may not be. So this is something, generally speaking, you don't want to rely too much on, but it's there nonetheless. So let's talk a little bit about trust planning when we're talking about protecting our loved ones. Now, this doesn't necessarily speak to you during your lifetime, but we want to reiterate, and this is back to our November workshop, when you pass away and your trust is held for your spouse, let's say, in a marital trust, or it's held for your children in a continuing family trust, is that protected from the claims of creditors? What do you think? Yeah, you know, it depends. And remember my old thing about lawyers sell more depends than CVS and Walgreens combined. But it does depend on whether it's, for example, we were talking about this in great detail in our November workshop, whether it's a proper discretionary trust and who the trustees are and what powers they have. But generally speaking, when you pass away and you leave a discretionary trust for the benefit of your spouse or your children, you can protect those assets. At least you can protect them while they're inside the trust. Trying to protect them as they are distributed from the trust is an entirely different subject, and that's what we talked about last November. But there's something you can do during your lifetime if it makes enough sense for you. Not many of you are going to want to do this, but we just throw it out to you as an option. What some people do, if they're worried about these sorts of things, and if they have a significant estate, is we'll create something called a lifetime marital trust. What's that? You know what a marital trust is at death, right? A marital trust says, at my death, it goes to my spouse, all the income goes to my spouse for the rest of her life, and then at her death it goes maybe, to my kids or wherever else I want it to go. I don't have to wait till I die to create one of those things. I could create a lifetime marital trust for my spouse now, and she can create one for me. And that offers some level of creditor protection, doesn't it? You can even create as a grantor trust with discretionary income distribution, so it's technically not a marital trust for the estate tax laws or gift tax laws, but depending upon your tax situation, that might not be a problem. So you can create discretionary trusts for each other during your lifetime if you're married that could protect from the claims of creditors. And that's one technique we use. It also is a neat technique because generally speaking, when the spouse dies, that money would then go to, let's say, your children. And the main objection that people have with these types of trusts is, hey, if I create a marital trust for my wife now, or my husband now, and then he dies before me, all those assets are gone and I can't use them anymore. Right? Wouldn't that be a concern? But the tax law actually gives us a break. We can route that money, that income, back to the original grantor and not lose the marital deduction. So there's possibilities there if this interests you, if this is something that you want to pursue. It's usually only pursued by those who have estates that are taxable because there's other reasons to do it besides for credit protection. And by the way, do you all know what the estate tax exemption is this year? It's $5.43 million in 2015. It's indexed to inflation. That's per person. So you and a spouse, if you're both alive, can shield up to $10.86 million. It's a lot of money. So that's very good. So that's one avenue. Let me talk about another one. Another one is to create a family limited partnership or an LLC, a limited liability company. Now this is particularly helpful. Remember when I talked about those of you who own rental properties, right? Do you remember I said that real early? If you own a rental property and it's in your revocable trust and there's a tragedy in it, someone, the property burns down, you didn't keep the battery in the smoke alarm, you're negligent, they sue you, they can get to the value of the property itself, of course, right? But can they get to all your other assets? Yes, if it's held by your revocable trust, can't they? Right? So as far as that rental property is concerned, you probably want to segregate that asset. You want to segregate it into another entity. And one of the ways to do that is to create like a partnership entity or a limited liability company, put that property in the company, and then your trust owns the property. Now, it's a little bit more technical than what I'm giving you the surface of this. It's a little bit more technical than what I'm talking about right now, because you actually have to have partners in it. It can't just be you. Single member LLCs are possible, but they don't really offer much asset protection. There's a case out there, what's it called, the Albright case? It's out of Colorado, and a lot of other states follow it, that single member LLCs don't necessarily protect us. But we can create, our trust. If we have a spouse, our spouse can own part of the LLC. And if we don't have a spouse, we might create a lifetime trust for our children that own some small percentage of the LLC. That way we're not a single member partnership. We have more than one. Does that make sense? All right, sorry about all the feedback. The last thing that Mike and I want to talk to you about before we open it up for questions is, all this sounds well and good, and a lot of people say, I'm fine right now. I don't have any liabilities, I haven't hit anybody in my car, no kid is drowned in my pool, no one slipped and fallen in my business, so I'm fine. I'll worry about this when something happens. Is that a good idea? Why isn't it a good idea? Yeah, well, it's too late because, for example, if I were to go buy an umbrella, like if I got cancer, God forbid, right now, and I went to go buy a life insurance policy, do you think they'd cover me? No, or they might. Yeah, we'll do $1 million policy on you. The premium's $995,995. So, and the same thing holds true with an umbrella policy. If you wait until there's a problem to buy that umbrella policy, chances are you're not going to be covered for the incident that currently exists. But the same holds true with almost everything else that Mike and I have talked about today. Aside from about the only thing that you can do is that Habakkuk case, the homestead exemption. Remember that you can dump more money into your house. You can even buy a bigger house. And for unknown reasons, the Florida Supreme Court said, that's okay. You can take non-exempt assets and make them exempt by dumping them into your house. But aside from that, almost everything else that we've talked about today, buying assets that are in statutory exemptions, setting up lifetime trusts or setting up LLCs, if you've waited until the problem is on the horizon, if you waited until those dark clouds are gathering, chances are, and you don't have to, by the way, the lawsuit doesn't necessarily have to be filed yet. If the incident has already occurred that could lead to that problem, something called the fraudulent conveyance or the fraudulent transfer laws would apply. Do you know what those are? Now, a lot of people think that's a criminal liability. When you start talking fraud, people think criminal liability. It's not criminal, it's civil. What fraudulent conveyance and fraudulent transfer laws indicate is, let's say I'm forthepeople.com, and I'm going after you, and we discover that you transferred $1 million into an annuity right after the accident. We're going to go to the judge and we're going to say, under the Fraudulent Transfers Act, this transfer should be undone because they knew of the potential liability and they converted what was otherwise non-exempt assets into exempt assets. And the judge would likely agree with them on something that clear cut. So you want to do, if you're going to do more advanced planning for asset protection, you want to do it while the skies are blue and not after something's happened. So that's really about what Mike and I have. Let's open it up for questions, for a few questions, and we'll stay after for anybody who has anything. Look back periods. I'm not aware of any look-back periods, so to speak.
No, really, it's a matter of, did you know or was it reasonably ascertainable that you were going to have a creditor when you made the transfer? That's for, your general liability. There are some bankruptcy look back, some clawbacks for transfers prior to bankruptcy. I'm no bankruptcy attorney by any means, but I know a little bit about it. And then obviously we didn't talk today about long-term care or Medicaid planning. Really, the big look back is if we're making transfers for purposes of long-term care and divesting ourselves of assets to be eligible for Medicaid or something along those lines, then there's a 5-year look back on those transfers. So, kind of depends on the creditor. Yes, ma'am.
Yeah, that's a good question. She's asked about subchapter S corporations. Yeah, corporations will generally provide you a veil of protection. The reason that I mentioned Florida limited partnerships and LLCs in particular is because the Florida statutes, I probably should have mentioned that.
Charging order.
The Florida statutes have something called charging order protection. Let me explain what that means. Charging order means, okay, let's say I know you have a partnership and I'm one of these plaintiff's lawyers. I'm going to seek the best I can do. I can't force you to liquidate your partnership under Florida law, but I can get a charging order against any distributions from that partnership, meaning that I'm first in line. If you're going to make a distribution of that partner as the creditor, I'm first in line. But there's a lot of problems with that charging order. You might decide not to make any distributions from that partnership for quite some time, right? You're going to try to frustrate the creditor, which could lead to a settlement, right? You're going to try to say, I'll pay you 10 cents on the dollar because I'm not making any distributions from this partnership. That's one strategy. So Florida offers really good creditor protection for LLCs and family-owned partnerships. S corporations, the problem you have with an S corporation is that income is getting K1'd out to you every year, and if you can't make a distribution to cover your taxes because you're trying to frustrate a creditor, you have some issues. Same thing in a partnership though, but here's a neat thing about a partnership, and this has never really been tested in Florida courts yet. Mike and I put these in our operating agreements as standard items. We'll say that if you have a charging order, you get the K1. So if I'm a creditor and I have a charging order against you, okay, and there's $100,000 of income associated with this particular partnership interest, the partnership agreement says K1 that to the creditor. So the creditor gets a K1 for $100,000.
What's the problem with that?
They got to pay taxes on it.
Pay taxes on it. Are they getting a distribution from the partnership to pay the taxes? No. So they've got, it's called phantom income. So they got $100,000 of income. They got to pay $30,000 to IRS, and they don't have any money from the partnership to do it. So,
the neat thing about, what Mike's saying is the neat thing about what partnerships and LLCs you can do is put these types of provisions in. You don't know if they're going to work or not, but you can put them in, and that could halt their progress so much that they say, you know what, we'll settle with you, or let's figure something else out. Right. And by the way, if you already have a problem, a lot of times what we'll do is we'll get a bankruptcy attorney involved, not just to get them in, not because you're necessarily going to declare bankruptcy, but to put that on the table so the creditor knows that if you do that, they might get nothing. Yeah. So there's all sorts of things we can do if you already have the problem too. Yeah.
Can you do a Florida LLC on a building in another state?
Can you do a Florida LLC in a building in another state? Yes, yes. Or you can even do an LLC in the other state and then have a Florida LLC own that as a single member LLC. So that way you get the charging order protection in Florida.
What if the other state has taxes?
What if Oklahoma has taxes? I know where they're from. If you have source income in that state, the Florida LLC isn't going to avoid it.
But you'll be able to piggyback off of Florida's LLC statutes, asset protection statutes, which is why you'd put it in a Florida LLC to begin with.
Yep. IRA and
IRA assets. Actually, no, they don't. IRAs are creatures of state. 401ks are. So I didn't mention ERISA or anything like that, but 401ks are governed by ERISA, which is the federal health, employee retirement, whatever it stands for. And those are protected under federal law. IRAs are not. They're a creature of state, and each state has their own exemptions for IRAs. And Florida, like I said, is a real good one. Florida is unique in that.
Let's repeat the question.
Yeah, the question was, again, buying property out of country, though, right? So, I mean, again, if we have out of country, typically we like to talk to the local council there because different countries tax transfers to trust very, very differently. So I know Canada has a capital gains tax when you
Right.
transfer your asset to a revocable trust, which we don't want to do. We don't want to incur that. So when it comes time, let me know. But generally speaking, we want all your assets in the trust if possible.
Yes, sir.
I have a farm in Iowa which has no structures except for 2 grain bins, and it's on cash rent. Should I consider the family limited partnership LLC?
Farm in Iowa.
You, it's in a trust to me.
Is someone farming the land?
Yes.
Are they using farming equipment?
Of course.
Yeah. Again, you could rely. The question was, if we have farmland up north, you're not really operating it; somebody else is operating it. Should you consider an LLC or some type of protected entity rather than just having it in your trust? And if you don't, you're running the risk of whoever the operator is having adequate insurance. And are we going to, you're assuming that they're going to have insurance to cover that slip and fall or that accident. And if they don't, they're going to look at the landowner for some kind of negligent leasing of it
Now,
to.
now some,
I have liability.
Sure.
yeah.
Right.
Well,
You lost me on that family limited partnership.
Well, remember, the partnership and those sorts of structures are there just in case you have a liability that exceeds your insurance.
Or insurance doesn't cover.
Or
for some
insurance won't
reason.
cover it for one reason or another. So that's a concern. Now, different state laws may apply. I don't know if farming land might be somehow exempt in Iowa. That's something we want to talk to Iowa Council about. For example, in Colorado, they have skiing and they have horseback riding, they have whitewater rafting. It's very, very, and I can tell you from personal experience because I was thrown off a horse a few years ago in the mountains of Colorado. Those waivers that you sign are really, really effective in those states. I mean, if you die whitewater rafting, you're not really going to be able to go very well against the company. So, the farmland might be covered in Iowa somehow too. That'd be something we want to investigate before sticking you in a partnership. Did you have a question? Yeah.
You said an annuity that's purchased out of state may not be protected.
Right.
What if that annuity is in the IRA?
That's a good question. The question is, annuities that are purchased outside the state may not be protected. What if that annuity is inside the IRA? Well, then we're looking at both statutes. We're looking at the IRA statute. But remember, we also said that there's some concern that if the IRA isn't governed by Florida law, that it also might not be protected. So that would be an issue.
But we look at both states. John?
I'm sorry. Go ahead.
What's the best way to protect inherited IRAs?
Yeah, best way to protect inherited IRAs. We actually talked about this at the last workshop in pretty good detail, but we set up a retirement plan trust. We call it an IRA trust. And what it is if it's your IRA will typically pass to the spouse because your IRA is protected for you. When it rolls over to the spouse, it'll be protected for him or her. And then when it drops down to the kids, instead of just giving it to the kids, we transfer it to, make it payable to a retirement plan trust for each one of them. So each one has their own little sliver of this separate trust. It's got all the bells and whistles for IRAs and the required minimum distribution rules to make sure that we comply with that. Because what we're looking for is we don't want just protection, that's important, but we also want to be able to stretch all the income tax recognition out. And so with the IRA trust, we can get both of those aspects. Thanks,
There's
John.
one in the back. Let me go back there first. Yeah.
Is the exemption, the wage exemption,
The wage exemption.
is it anything that's on a W-2, specifically on referring to will you have deferred wage income
Deferred wage income.
being paid out?
That's an interesting question.
I would think it would
I think
be
it would be.
earned income.
Yeah.
Would be my. I don't
Well,
know the answer if it's
earned-
deferred income, even if it's W-2. I don't know. We'd have to look a little closer at that. But I would think it would be just the current earned income, not anything deferred.
We'll take a couple more and then we'll say later for others. Yes.
Is life insurance purchased while not a Florida resident?
I believe life insurance that's purchased before you're a Florida resident would be protected as long as you became a Florida resident.
I've never heard any chatter about life insurance cash surrender value not being, like with the annuities and with the
Right.
IRAs.
In the back.
Question on life insurance. Is it better to have the beneficiary take the life insurance
typically what we'll do with the life insurance is I'll typically name the spouse as the primary beneficiary and then the trust as the contingent beneficiary. So what'll happen is it'll just go to the spouse at the death of the first spouse, and she'll put it in her IRA or in her revocable trust. But if she's gone as well, then it'll funnel to the kids through the trust. Because otherwise, what could we have? If my trust has all these fancy bells and whistles and all these provisions and all these what if so-and-so predeceases and all the what ifs, we can't do that in the beneficiary designation. So the next best thing is just to route it through the trust. And so, yeah.
One more question here, and then we'll stay later.
My wife and I each have a revocable trust.
Right,
If something happens to me, she's the beneficiary,
right,
while I'm the beneficiary in her trust.
correct.
Why would we need a family trust?
Well, the question was, if we have trusts that are set up for each other, do we need more creditor protection? Why would we need a family limited partnership? You don't necessarily need one. It's all facts and circumstances. Remember, guys, what we're talking about today is a real general overview. For many of you, an umbrella policy is going to be sufficient.
Yeah.
For many of you, an umbrella policy is going to be sufficient. But for those of you who have a little bit more estate value, or for those of you who don't want to
risk factors.
or you have higher risk factors that we put up on the board, those are when you might want to think about some of the other considerations that Mike and I discussed. We're going to stay later here to answer any other questions that you have. Thank you very much for spending your valuable time with us. We hope you found some good